So what was done by the TRIPS agreement? As we can understand, at the time of signing of the TRIPS agreement, and especially during the Uruguay round negotiations, modern biotechnology had already made its dent. So practically there were new products that were coming into the market. People were investing quite a lot in biotechnology, and hence there was definitely an interest in getting biotechnology subject matter included in the TRIPS agreement. So Article 27.1 says that any invention, which means all kinds of invention, whether biotechnology or not, should be patent eligible. Any invention, when it involves an inventive step, novelty and industrial application, must be allowed for a patent. And there shall be no discrimination as to the field of technology, which means you can't distinguish saying that this is a patentable subject matter that relates to biotechnology or life patents. Discrimination on the basis of the place of invention, discrimination on the basis of whether it has been locally produced, cannot be made by virtue of Article 27.1. And the only exclusions that are allowed are in Article 27.2 that relates to order, republic and morality, and Article 27.3, especially Article 27.3b, that relates to exclusion of biotechnology subject matter. And it says, I quote, Article 27.3b, members may also exclude from patentability plants and animals other than microorganisms, and especially biological processes for the production of plants and animals or animals other than non-biological and microbiological processes. However, members shall provide for the protection of plant varieties either by patents or by an effective sui generis system or by any combination thereof. The provisions of this subparagraph shall be reviewed 4 years after the date of entry into force of the WTO agreement. Now this seems to convey that there was a lot of concern raised by largely those members which were their opposition to patenting life was largely based on ethical considerations, mainly from the Judeo-Christian tradition, when the church was strongly opposed to any kind of research involving biotechnology. Now, post-TRIPS, many countries have implemented the mandate of having biotechnology subject matter application accepted in their patent offices, but certain recent decisions have actually questioned the scope of patentability of subject matter. Now, the first cases in this regard, a recent case, is Association for Molecular Pathology versus Myriad Genetics. This is the US Supreme Court decision in 2013. The question here was whether or not human genes are patentable. Now, human genes have been patentable for long. There were a lot of gene sequences that have been granted patents by the Patent Office for the last 30 years, and now this question is figured in 2013. So in this case, the court said it is important to note that what is not implicated by this decision. First, there are no method claims before this court. That's what the court said. Had Myriad created an innovative method of manipulating genes which, while searching the particular genes, that is BRCA1 and BRCA2 responsible for breast cancer, it could possibly have sought a method patent. But the process used by Myriad to isolate DNA at the time of Myriad patents were all well understood, which when were widely used and fairly uniform insofar as the scientist engaged in the search for a gene would likely have utilized a similar approach. Similarly, this case does not involve patents on new applications of knowledge about BRCA1 and BRCA2 genes. And finally, the court said, as the first party with knowledge of BRCA1 and BRCA2 sequences, Myriad was in an excellent position to claim applications of that knowledge. Many of its unchallenged claims are limited to such application. The court also further on went on to say, nor do we consider the patentability of DNA in which the order of naturally occurring nucleotides has been altered. Scientific alteration of genetic code presents a different inquiry, and we express no opinion about application of section 101 to this such endeavors. We merely hold that genes and information they encode are not patent eligible under 101 simply because they have been isolated from the surrounding genetic material. Now, there was a concurring opinion which also relates to scientific details, and Justice Scalia wrote, I join the judgment of the court in all of its opinion except para 1a and some portion of the rest of the opinion going on into fine details of molecular biology. I am unable to affirm those details on my own knowledge or my own belief. It suffices for me to affirm, having studied the opinions below and the expert briefs presented here, that the portion of DNA isolated from its natural state sought to be patented is identical to the portion of DNA in its natural state, and the complementary DNA, cDNA, is synthetic creation not normally present in nature. Now, the impact of this decision, or the ratio of decision, seems to be that if your claims are directed towards the gene sequences that are present already in nature, and what you do by simply isolation and purification and identifying the particular gene sequence, that will not entitle you for a patent. But having said that, if you come out with certain genetic sequences through cDNA, that is synthetic creation, these can definitely be patented. Now, there are some critics of this decision, but other critics have pointed out primarily that such a decision may have impact on biotechnology industry, but some others believe that the time for this decision is already over, because a lot of these early patents that were granted were in 1990s, and that this decision may not be so relevant in the context of the second half of the second decade of the 21st century. The second case that is important in the context of diagnostics is Mayo versus Prometheus. This decision is decided by the US Supreme Court in 2012. Here the claims were directed to a method of giving a drug to a patient. Now, what happens is, you need to know what is the right dosage that a patient has to be given. So here the invention was relating to measuring metabolites of that drug and with a known threshold for efficacy in mind, deciding whether to increase or decrease the dosage of the drug. Now, in this case, the court said the correlation between naturally produced metabolites and therapeutic efficacy and toxicity to be an unpatentable natural law, and it also found that the first two steps to be not genuine applications of these laws, but rather drafting efforts designed to monopolize the correlations. Now, the court was saying that because these methods for making such determinations were well known in art, that is in prior art, and this step simply tells the doctors to engage in a well understood routine conventional activity previously engaged by certain scientists in the field, such activity is naturally not sufficient to transform an unpatentable law of nature, and the court seems to think that such correlation is a kind of unpatentable law of nature, and so it is saying that such unpatentable law of nature you cannot translate into a patentable subject matter application of such law. The conclusion is that 1. A newly discovered law of nature is itself unacceptable, unpatentable. Second, the application of the newly discovered law is also normally unpatentable if the application merely relies upon elements already known in the art. Now, of course, there were questions relating to impact of this decision on the industry. The court also took it head on and said, in consequence, we must hesitate before departing from established general legal rules, lest a new protective rule that seems to suit the needs of one field produce unforeseen results in another. And we must recognize the role of the Congress in crafting more finely tailored rules where necessary. We need not determine here whether, from a policy perspective, increased protection for discoveries or diagnostics laws of nature is desirable. So that question, they said they would leave it to the Congress to decide, so that they could come out with more finer rules relating to patent law that allows such diagnostics to be patented. Now, what is the position in India? If you look into the historical position, section 5.1 was interpreted, that is prior to amendments, to mean that some substances like microorganisms were capable of being used in medicines, food, and they could be produced by chemical processes, biotechnology, biochemical, microbiological, and these would be excluded from the definition of 5.1. And 2002 amendments, you can check, added an explanation for the clarification. But the 2004 5 amendments repealed Section 5 completely to bring in line with the mandate of the TRIPS agreement. Now, what does it then say? One of the early decisions, and this was prior to the 2005 amendments, is the Dimminaco AG versus control of patents. In this case, the invention was relating to an investigation related to process for preparation of infectious bursitis vaccine. Now, the question is whether it's a useful. The invention is actually useful for protecting poultry against contagious bursitis and contains a living virus, as in case of any other vaccine. Now, since this vaccine contained a living virus, the patent office seemed to have rejected the application. It went on in appeal to the Calcutta High Court, and the decision of the High Court is very interesting. The court propounded something called as a vendibility test. It said that if a product was vendible, it should not matter whether it is a live subject matter or not. Now, and it rejected on grounds of Section 21J, as it then was. It said administrative policies and wordings in the Act must be differentiated. You should look actually into the wordings of the Act. No case of granting patents on living matter except lofsiling, drying of materials in the frozen state. Meaning given to the word manufacture was discussed. However, the process patents allowed as under Section 5 are not excluded. Now, post this decision, there was a lot of discussion, and then finally you had the 2005 amendments. Now, the thumb rule is that all inventions pertaining to living subject matter except as ruled out by Section 3 are patentable, which means Indian law does not discriminate between biotechnology and non-biotechnology subject matter. All kinds of subject matter are routinely accepted by the patent office, but there are certain exclusions. We'll discuss few of them in this particular module. Section 3B allows exclusion based on public order, morality, and which causes serious prejudice. Now, the test for public order or morality, or which causes serious prejudice to plant, animal life or human life, is not primarily relating to the invention being per se immoral, but the test is based on the commercial exploitation of such invention. So only based on the commercial exploitation, it means there must be some kind of external law to prohibit such a product as contrary to public order, morality or causing serious prejudice, and then definitely there is a strong ground for the patent office to reject such patents under Section 3B. Section 3B derives its strength from Article 27.2 of the TRIPS agreement, which allows for such exclusions. So WTO member countries are free to allow such exclusions. Section 3C is a very interesting provision which primarily makes the distinction between invention and discovery, which says that mere discoveries of any living thing or non-living substance occurring in nature is not patentable. Now, everything is fixated around the word mere, and how do you interpret mere discovery vis-a-vis kinds of discoveries we have in biotechnology subject matter, wherein genes are routinely isolated and purified, and subsequently the express sequence tags are patented through various types of claims. There are express policy considerations that are employed in Section 3J, wherein the exclusion extends to plants and animals in whole or in part. It also excludes seeds, varieties and species, essentially biological processes for the production and propagation of plants and animals, but as per the mandate of the TRIPS agreement, wherein microorganisms must be patented, here also in India microorganisms are allowed patents. Now, the scope of microorganisms is highly contentious, whether it includes certain kind of genetically modified organisms, and to what extent does it extend to higher life forms. Secondly, whether it could also include viruses, whether they are living, non-living. How do we actually interpret the term microorganisms is highly contentious. The fourth kind of exclusion relates to methods of treatment exception, whereas diagnostic, therapeutic, surgical methods that are used for treatment of humans are excluded. Now, Section 3P is another exclusion, that is a fifth final one, wherein traditional knowledge or an invention that is essentially based on traditional knowledge is excluded. So these exclusions have huge implications on biotechnology subject matter. Now, we have the biotech guidelines issued by the Indian Patent Office. You can refer to your module wherein the exclusions and their possible meaning have been discussed in detail. One of the important things that need to be understood in the context of TK associated with genetic resources is, because of our experience in neem and turmeric patents, we thought it would be a defensive strategy to prevent biopiracy, or call it bioprospecting, by having section 3P. And based on section 10 requirements, you now have the disclosure of biological source and origin of the particular biological material, wherein such material has to be deposited with the repository, wherein without such disclosure, the patent application is, or the grant of the patent is liable to be revoked. Section 10.4 deals with sufficiency of disclosure and the best mode of performing the invention, and section 5 deals with 10.5 deals with the unity of invention and the support of the claims, which are all relating to how you claim biotechnology subject matter. It will be important to revisit the biotech guidelines of the Indian Patent Office along with the manual of patent practice and procedure, and also the TK guidelines that are issued by the Indian Patent Office, to understand the nature of what is excluded and what is included. There are very fine illustrative examples given in those guidelines which can be used by patent applicants to narrate their subject matter and the type of claims that they can make and gain patents for. In summary, modern biotechnology has definitely helped markets to bring innovative products that are highly technology intensive. The role of biotechnology in bringing out these new products in the form of medicines, agricultural biotechnology, has immensely helped the markets and the society towards gaining from the fruits of this modern technology. Second, the role of patent in incentivizing biotechnology is important, and there are certain challenges that the patent system has itself produced to biotechnology and vice versa. The early origins of patenting biotechnology subject matter from a comparative jurisdictional perspective and in India has been thoroughly discussed in this module. The patent eligibility of the biotechnology subject matter through various sections, through various provisions in the context of the TRIPS agreement has been elaborately discussed in this particular module. And finally, we have also discussed in the context of Indian Patents Act 1970 several provisions relating to both patent eligibility and patentability of biotechnology, specifically in the light of the guidelines issued by the Intellectual Property Office in 2013. Thank you very much.